Welcome to the Veritas Forum, engaging university students and faculty in discussions about life's hardest questions and the relevance of Jesus Christ to all of life.
What I'm going to try to do with my 10 minutes is actually tell you a little bit about what my provocatively titled book is about, because while it has a provocative title, it has a less provocative conclusion. And then maybe in the course of our dialogue, we'll get more specifically into some of the questions that Jordan raised. Right? So here's the question I'm concerned with in Why Tolerate Religion. It is an argument for religious toleration, right? But the answer to the title question, Why Tolerate Religion, is that the reasons to tolerate religion are not specific to religion. I argue that over the last couple hundred years, in competing moral and political philosophy traditions, broadly Kantian utilitarian traditions, we have developed plausible, compelling arguments for thinking that the liberty of individual conscience is something important and valuable that liberal and just societies should protect, and that protection for liberty of conscience encompasses liberty of religious conscience as well. Right? So it is not an argument for religious intolerance, but it is an argument that the grounds of toleration are not specific only to the claims of religious conscience. And this is interesting as a matter of law, because in all the Western democracies, liberty of religious conscience is given a special place. Now, this is not surprising in the United States because, of course, the First Amendment mentions only the free exercise of religion. It is a little more surprising in other democratic societies. Right? So take the Canadian Charter, specifically mentions liberty of conscience as well as liberty of religious conscience. European Convention on Human Rights mentions liberty of conscience as well as religious liberty. Yet the reality in all of these legal systems is that the only time that challenges to laws of general applicability are upheld and exemptions are granted, right, are for those complainants who have religious claims. Now, there's one exception to that even in the United States, which has to do with military conscription. Let me just say a very brief word about that. Some people in the audience are old enough to remember when there was military conscription. In 1970, well, starting in the late 60s, some people sought exemptions from the military draft on the grounds that they were conscientious objectors to war, but not religious conscientious objectors. There were, of course, religiously motivated conscientious objectors as well. Supreme Court eventually decided that a non-religious conscientious objector to war can be exempted from military service, but they did not decide that as a matter of constitutional law. They decided that as a matter of statutory interpretation, an interpretation of the Selective Service Registration Act, which is what authorized the military draft. Now, the reason they did that is because if they constitutionalized the possibility that non-religious claims of conscience would have the same standing to challenge the application of a law, they would have opened the door, of course, to a whole host of challenges to many different kinds of laws by people with all kinds of claims of conscientious objection. Now, one of the questions I'm concerned about in my book is whether there is a good reason to think that we should only grant exemptions for religious claims of conscience. Now, for reasons of time, I'm not going to go into all the details of the argument here, though we may well touch on them in the course of the discussion. And just to be clear, I understand what the historical reasons are, right? We all know, I think, what the historical reasons are. During the early modern wars of religion, in which people slaughtered each other over their sectarian differences, They eventually came to the conclusion, right, that it would be a lot better to live and let live in matters of religion, right, than to endlessly try to convert the people you thought were the heretics. And that was certainly a very fortunate compromise from which we have all benefited. Right? That's the historical reason why the American First Amendment is religion-specific. One of the questions we have to think about today in the 21st century is whether there are still reasons to think only religious claims of conscience, right, deserve special legal consideration. And since I think the strongest arguments are for liberty of conscience generally, not just liberty of religious conscience, I think the inequality in American law between religious and non-religious claims of conscience, with the exception of military conscription, I don't think that is defensible any longer. And so that's part of what I am arguing in the book. Now, in the final chapter of the book, I take up a slightly different question, which is, if my argument is right, if there are good arguments for liberty of conscience, but they are not specific just to religious claims of conscience, what should we do with regard to exemptions? And of course, there are two possibilities. One is we could just have a universal scheme of exemptions in which anyone who has a conscientious objection to a law of general applicability could bring that objection to court. Right? And just a quick side note about this phrase I've used, a neutral law of general applicability. Right? We're talking here, right, about laws that apply generally and whose purpose isn't, whether it's explicit or implicit, to persecute a particular group because of their religious beliefs. Okay? Everyone has agreed that laws like that are unconstitutional, even if framed in a way that makes them look superficially neutral. So we're talking about genuinely neutral laws of general applicability that happen to burden the free exercise of religion, or, as I would have it, the free exercise of a claim of conscience. And let me just say what I mean by a claim of conscience. By a claim of conscience, I mean a claim of the form that a person experiences that there are certain things I must do and certain things I must not do that are categorical, right? They're not up for negotiation. And I take it to be a distinctive feature of all religions that they make at least some categorical demands on their adherents, that certain things are not negotiable, okay? And this, of course, is why religious adherents sometimes come into conflict with the law, right? But it is my view that there are plenty of claims of conscience for plenty of people now that do not derive from a sense of religious obligation or religious belief. So I do not think that the sense of conscience is peculiar, right, to religious adherence, and if that is correct, then the inequality in our current law between religious and non-religious claims of conscience requires some scrutiny. So as I said, one possibility would just be to opt for what I call a universal scheme of exemptions. Anyone would have standing on conscientious grounds to challenge the application of a law. There are many practical problems, you might imagine, with such an approach, and we'll probably talk a little bit more about that. But one of the things I emphasize in the final chapter of my book is there's another consideration we need to take seriously, which is that the granting of exemptions to neutral laws of general applicability, right, sometimes impose serious costs on other members of society. Not always. Some exemptions are what I call non-burden shifting exemptions. But some exemptions are burden shifting. And let's take a very au courant example, right? Exemptions from mandatory vaccination schemes. Right? The return of whooping cough, of measles, especially in the Western United States, is attributable entirely to exemptions to those vaccination schemes. Now, those exemptions are not always religious-based exemptions. Indeed, in California, and of course this would be California, you can get an exemption from mandatory vaccination for philosophical reasons, okay? Now, The real problem there, of course, is that you don't actually have to have philosophical reasons, right? You don't have to submit a 10-page paper explaining, right, giving arguments. You just check a box. So to some extent, the exemptions that we grant to schemes of mandatory vaccination are just handed out too loosely without enough scrutiny. But it's still a good example where exemptions impose costs on other people, because mandatory vaccination schemes only work if a very significant portion of the population is vaccinated, right? And as that number goes down, the holdouts can no longer free ride on everyone who's vaccinated, and there are real consequences. So I think we have to think very seriously about whether all claims for exemption should be permitted. And what I argue in the final chapter of the book is that where exemptions are not burden shifting, right, then both the religious and the non-religious should have legal standing to raise a conscientious objection to the laws that burden them, right? But that where they are burden shifting, we should be skeptical about whether the exemptions, in fact, should be granted, right? And that will sometimes, right, render unavailable certain kinds of exemptions that religious claimants might bring. I'll note that the proposal is not very inconsistent with the actual state of American law, right? So when religious groups have raised objections to paying taxes, guess what? They lose, right? Because the court concludes that, right, there is a compelling interest in the raising of revenue, and it can't be done in any other way than requiring everybody to contribute through the tax system. So that's, in sort of summary form, an outline of the main claims that I try to defend in my book, and I think that's probably a good place to stop and cede the floor to David Skeel. Thank you.
So the first question that Jordan asked us to address is whether our position on the special legal status of religion has changed in recent years. I suppose I would have to say yes to that question, at least to say that my view on the hot-button issues involving religion have changed, and that the shift from one set of issues to another has dramatically increased my own interest and involvement in this area. Then, as now, I was writing, or let me back up a step, I should say, that my interest in this area goes back 10 or 15 years. I've been teaching for 25, so it goes back about halfway into my career. When I first started writing in this area, 10 or 15 years ago, then as now, I was writing as an evangelical Christian, which was and is still rather unusual for a law professor at a relatively prominent law school. For those of you who may be wondering what an evangelical Christian is, I believe that Jesus was resurrected from the dead, and that changes everything for all of us. Most importantly, Jesus has given us a way to be reconciled to the God from whom each one of us has rebelled. The big religion issues 10 or 15 years ago, when I first started writing about Christianity and law in particular, were disputes over whether Christian prayers could be said over the loudspeaker at a Texas high school football game, or whether the Ten Commandments could or can be posted in courthouses and in other public buildings. Some of you may remember, some of you probably don't, but at least a few of you may remember that a few years ago, an Alabama state court judge brought a giant rock that was on wheels with the Ten Commandments inscribed on it into his courthouse, and that raised a lot of excitement at the time. I personally had two general reactions to these debates about prayers at high school football games and the Ten Commandments in courthouses and the like. The first was that it seemed to me that a lot of energy was being expended on issues that did not appear to have great importance in the scheme of things. In my view, those issues were symbolic rather than real issues. The issues were a lot less important than the civil rights movement or William Jennings Bryan's populist evangelical campaigns of a century ago. My second reaction was that Christians often seem to me to be on the wrong side of those issues. In my view, non-Christians were rightly offended by Christian prayer at a Texas football game that seemed to have the imprimatur of the school. I think it's a mistake for governmental entities to be seen as taking sides in questions of religion. Now, one irony here with Brian and I having this conversation, and Brian didn't talk about this part of his book, but one irony is that Brian might be a little more comfortable with the government taking sides on these kinds of issues than I am, although I suspect Brian isn't a huge fan of prayer at Texas high school football games, and Brian has probably been to one or two of those high school football games since he taught for a long time at the University of Texas. More recently, many of the high-profile public controversies have involved the free exercise of religion. They are questions such as whether a religiously oriented for-profit business like Hobby Lobby should have religious freedom rights, and whether a New Mexico photography business should be permitted to refuse to take pictures at a wedding if the couple involved is lesbians. I think these issues are much more important, much more interesting, and in many respects, much harder than the issues of 10 or 15 years ago. And I think they're the issues that we'll mostly be talking about in our conversation. And in particular, as we get into the issue of what special protection of religion means and whether that's a good idea or a bad idea. Before I say a couple of words about that, I want to say a few words about toleration. In Brian's book, which, as Jordan has done, I would strongly encourage y'all to read. It's a fascinating book. Brian defines toleration as, quote, putting up with views with which we disapprove. Now, Brian is defining toleration in a very particular way for a very particular purpose, his analysis of whether there's a principled reason to give religion special treatment, as he was just talking about a moment ago. For our purposes tonight, I think it's very important to distinguish what toleration means in two different contexts. The first context being when it's the government we're talking about and whether the government is tolerating or not. And the second context being our interactions as individuals and what toleration might mean in that context. With the government, I believe that toleration should mean neutrality. The government should not either favor or disfavor any particular religion or other set of views. As individuals, I think toleration doesn't mean neutrality at all, and that it's more than simply putting up with views with which we disapprove. In my view, tolerance, in the individual context, or what's sometimes called deep tolerance, means taking one another's deepest commitments seriously and trying to understand and engage them, even if we find them wrong-headed or offensive. As for the special protection of religion, the first thing to note is the obvious point that the Constitution quite clearly provides special protection by saying in the First Amendment that the government can't establish a religion and it can't interfere with the free exercise of religion. So if this were a debate rather than a friendly conversation, I win. But since it's a friendly conversation, I'll turn to the real question, which is whether we should rethink and back away from the special treatment of religion that we currently have in the Constitution and the Religious Freedom Restoration Act. One of the main arguments against special treatment of religion is that religious belief can't be distinguished from conscience. And Brian elaborated on that in some detail just a few minutes ago. And the idea is that since they're more or less the same thing, it isn't fair to give special treatment to religion, but not to issues of conscience, of secular conscience. I do think there are key similarities between religious belief and conscience, but that religious belief isn't simply a subset of conscience. Indeed, as a historical matter, it might be more accurate to say that conscience has been a subset of religion, since religion played a central role in the formation of conscience for almost everyone. There were very few claims of conscience that were non-religious claims of conscience. This is something that's changed more recently, as Brian also noted. Religion also makes a more comprehensive claim on adherents' lives than many claims of conscience do, and it usually has a necessary institutional dimension. It's not simply individual. Rather than erasing the special circle around religion, I think it would make more sense to expand the circle slightly to protect claims that have many of the same qualities as religion. The Constitution already does this to some extent by protecting free speech and association and related values. And the classic example of courts expanding the protection or expanding the circle of what counts as religion for the purposes of protection is the case that Brian talked about involving conscientious objection to the Vietnam War. Often the subtext of arguments for eliminating the special treatment of religion is a perception that religion in general, and Christianity in particular, is irrational and often harmful. But religion, or Christianity at least, isn't irrational at all, although after listening to me for a few minutes, you might be tempted to disagree with that. Christians do believe in the possibility, indeed the reality, of supernatural intervention in the universe, most dramatically in the case of Jesus' resurrection from the dead. Jesus' resurrection cannot be proven beyond any reasonable doubt. If it could, Brian would believe in it too, but it is backed by a remarkable amount of evidence. Christianity also provides surprisingly plausible explanations for many of the most puzzling aspects of how we experience the world. Why, for instance, do we have the ability to have conversations like the one we're having tonight? Very hard to explain why that would matter to us and why it mattered to us on the ancient savannah. Why do we experience beauty as transcendent and suffering as not just as a natural part of the natural order, but as somehow wrong, as somehow evil? These are the kinds of questions that I explore in True Paradox. I think Brian is right when he says in his book that the adherents of every religion are probably wrong about some things at any given time. But this does not mean, in my view, that no religion is true, as I deeply believe that Christianity is true. And most importantly, for our purposes tonight, I don't believe that the government is competent to distinguish among different religious beliefs, either to favor or to disfavor them. I'll conclude by briefly answering the second question we were asked to address, and that is, what is the most difficult or complex of the issues around toleration and the special treatment of religion? For me, the most difficult issue is deciding when the special treatment of religion should give way to other governmental objectives, such as making sure that all Americans have health care. And this is something Brian also talked about in some detail. The Hobby Lobby case raises these kinds of issues, as does the University of California's recent decision to de-recognize a Christian ministry throughout the California system, not just at Berkeley, because the ministry requires that its leaders be Christians. My own view of Hobby Lobby probably wouldn't surprise most people here, although my view of the University of California controversy might be a tad more surprising. As Brian talks about in his book, one of John Stuart Mill's principal arguments for toleration was the value of encouraging, quote, experiments in living. Mill argued that the, quote, worth of different modes of life should be proved practically. I think Mill is right about this. Protecting religious institutions' ability to serve as experiments in living may mean permitting exemptions from some requirements of the healthcare law, and it may mean resisting the temptation in the coming years to force religious institutions that hold to a traditional view of marriage to perform same-sex marriages. It won't be easy, given the growing heterogeneity in our society and the expanding governmental role in our lives, but I believe that the commitment to pluralism is crucially important, and that preserving and even modestly expanding the special protection of religion is absolutely essential to that goal.
So the first question that I want to get into with both of you is with regards to how you're going to define religion, because that plays an important part with regards to the issue of whether or not religion could be considered to be responsive to reason, evidence, in the same way, the way that we would want it to be responsive for a secular society, secular government. So I think I'll start with Brian on that question.
Okay. Is this on? Can people hear me? So I want to say I agree with 84% of what David said.
But I only agreed with 80% of what Brian said.
Okay. So I'll talk a little bit about how I try to characterize religion in the book. So I say, look, one thing you can't do in characterizing religion at the start is say, well, it involves belief in a supernatural deity, because you immediately lose about 800,000 to 800 million to a billion people, because Buddhism in most of its forms doesn't involve such a belief. And I think when we think about a question, what's religion, we ought to take seriously some of our what I call pre-theoretical intuitions, right? If you come up with a characterization of religion where it turns out Christianity's not a religion, Buddhism's not a religion, it's not a very good characterization. So I suggest that religions have three things in common. They have three characteristics, and all three are necessary, right? One is that all religions make certain kinds of categorical demands upon their adherents. There are certain things you must and must not do as a matter of your religious commitment. The second characteristic is that I think all religions involve some beliefs, not all beliefs, but some beliefs that are, this is how we put it colloquially, we say some beliefs that are held on faith, right? But I want to be a little more precise about that. I think what we're saying when we say they're held on faith, we're saying they're not held on the basis of what I'll just call ordinary or scientific standards of reasons and evidence, right? And all religions, I think, involve some beliefs that have that characteristic. I actually think the belief in the resurrection of Christ ultimately falls into that category, but that's something we can talk about. And then the third characteristic is that I think all religions, in one way or another, try to offer what I call existential consolation. That is, they try to speak to the important fact that, not to ruin your evening, but everybody here will die. Everyone you know and love will die. Some will die before you do. Everyone you know and everyone here will experience suffering or know people who experience suffering, pain, and hardship, right? So these are rather important facts about the human situation, and all religions in different ways, very different ways in some cases, try to speak to these problems. Occasionally someone will raise their hand at this point and say, what about Calvinism? Calvinism is tricky, but I think even Calvinism has an existential consolation dimension to it, even though in some of its more severe forms it may not be obvious to the non-Calvinist how that goes. So my claim is those are the sort of three distinctive features that pick out religion and religious claims of conscience. And I want to say actually one thing about conscience that was brought to mind by David's remarks, which is it's actually quite right that the modern importance we assign to liberty of conscience. And we can tell it's really important because, well, we talk about it, but it's in every single Western constitution and foundational charter of the last 100 years in one form or another. The importance of individual liberty of conscience. And I think it's quite correct that that is essentially a Protestant invention. Right? It grows out of the Protestant Reformation, right? And has now gradually become a kind of secular, right, article of faith, in the sense that people, regardless of their particular religious affiliations, nations, regardless of their particular religious traditions, now view conscience as quite significant. So I agree with, that was related to one of the things David said, but maybe that's a good point to start. So that's my attempt in the book to come up with a characterization of religion that does some justice to what we take to be the paradigm instances, and actually I think works pretty well when we confront some of the harder borderline cases.
I was going to say, I was going to ask you to do something additional to actually stating your view on how to define religion, but I actually wanted to add one thing that I think is pretty relevant to what you just said about liberty. One thing that you'll notice about human rights is a lot of the language with regards to human rights today is couched in, absolutist terms, and in the same way that Brian was talking about the Protestant, influence on the value of liberty and things of that nature. You'll see that with regards to human rights, where you had natural theology at the founding with regards to the Constitution. You see that play all the way up. So the additional question I was going to have for you was, in addition to the how do you define religion with regards to this, is one of the ways that you could counter Brian's argument is to just say, well, that might be true with regards to your definition of religion might be true, but then how does that differ with regards to political ideology, or just with everyone's types of different individual system of morality that people have? So that was the second question that how would you fill out that? Yeah, if you were going to, that's an obvious type of, I think, counter argument to him.
So maybe I'll answer the second question first. So what I would say is, I think political ideology doesn't tend to make the same comprehensive claims on our lives that religion does. So the first part of Brian's definition doesn't really apply to most political ideologies. But I would also say, channeling Brian, I think, that Brian's not trying to argue, Brian's focusing on why religion gets special treatment. And if political ideology, sort of, either way, I don't think it undermines Brian's argument. So that if political ideology is the same, then it raises questions about the special treatment. Even if it's different, that wouldn't necessarily mean that we ought to give religion special treatment. But I do think there's some differences, that most things like philosophies, political views, even things that people are passionate about, like Philadelphia Eagles for some people in my city, don't make this kind of comprehensive claims on one's life that religion does, and that is a distinction. But as far as religion and how to think about religion, a couple things about that. I thought I'd start out by saying, as a card-carrying Calvinist, my Calvinism provides deep consolation for me. So I'm a data point that even Calvinists have existential consolation. The second thing I wanted to say was, with Brian's definition, with its three parts, I really like the first and the third part. I like the categorical claim part of it. I think that's right. That is something that's essential to religion. I like the existential consolation. I might use a slightly different term, but I like that as well. The part of the definition I don't like is defining religion as insulation from evidence, or as not being connected to reasons, because obviously I believe that for religious believers, our faith is connected to reasons, and I think it's true for all of us that our comprehensive view of the world, whatever it is, whether it's a religious view or whether it's a non-religious view, consists of the best evidence we have available to us, plus a decision made under conditions of uncertainty. That none of us is absolutely certain, but all of us are making decisions based on evidence. And so I don't like the second part of Brian's definition, but I do like the other two. The other thing I would say about a definition of religion is I think it's really, really hard because religions are so different. In the founding era, what the founders would have been thinking about would be Christianity, Judaism, and to some extent Islam, and they would not have imagined Buddhism would be a significant part of what religion means in the United States. In my view, there are some things that tend to be different about religion, or that tend to be additional to what Brian talks about, such as religion typically is institutional in its manifestation and public rather than just individual, but not always. So I think inevitably the question, in answering the question, what is religion, we have to look to family resemblances, things that look like things we know to be religion, which is sort of circling back to what Brian said, that there's no precise definition that's going to encompass everything, but there are some features religion tends to have, and that ultimately we're looking at family resemblances. Does this look like the religions that all of us know to be religions?
You know, just on the institutional point, I mean, it is a curious feature, right, of the U.S. Supreme Court's doctrine, right, that they absolutely insist it's the sincerity of individual belief that matters, and not that you can point to the institution that you've been part of. So they really do make it very Protestant, very individual. Right. Now, that's the official doctrine. I think there's reasons, when you look at the claims that succeed, I think there's reasons for some skepticism about that, because the claims that succeed always turn out to be ones that you can sort of recognize there's some institutional practices associated with them.
Right.
So with regards to the, I'm actually going to maybe push Skeel a little bit on this, but asking Brian this question to get the ball rolling down this line of argument. So regarding the third part of your definition of religion, how would you say, if you think that it does, that religious belief differs from political ideology with regards to responsiveness to reasons and evidence?
Mm-hmm. Well, I think a lot of it does depend on what the political ideology is. Not all political ideologies are the same either. You know, David is quite right that a lot of them are not comprehensive. Though I have to say, it's worth keeping in mind, right, that a lot of religious practices for an awful lot of people are not comprehensive either, right? There's an awful lot of, shall we say, casual Christians and Jews out there, right?
Although they tend not to be making the claims on the legal system.
Yes, it turns out that the more casual you are, the less likely you are to go to court in order to ask for an exemption.
Go figure.
You know, so political ideologies can be different, but I think, you know, we have to be very sensitive to time and to place. So to take, you know, an example that will no longer has much resonance in 21st century America, but would have had a lot of resonance in Europe in the first half of the 20th century, were communists. And it was completely, right, comprehensive view, full of categorical demands. And indeed, as I note in the book, you know, if you look at Nazi Germany in the 1930s, and of course this was a brutal time, and repression, you know, of dissent was vicious, and the only sort of systematic resistors were, on the one hand, communists, and on the other hand, certain religious groups, right? And in both cases, I think that's because they took the categorical demands of their worldview sufficiently seriously that they were not going to be intimidated and dissuaded by the threat of vicious repression. Now, so that's just on the first part of it. Does that mean, and I actually spend some time talking in the book about this, does that mean that, communism was a religion? Well, it depends now on the other two characteristics and what we want to say about them. There were aspects of the communist movement that had existential consolation functions. A nice thing about being a communist, I hope that's not too shocking a thing to say these days, nice thing about being a communist, if you really believed it, was history had a necessary structure and it was going to end a certain way. That's actually that can be kind of cheery, at least if you think the ending is a good one, right? The hard question is about the relationship to reasons and evidence. And I do want to underline again that my thesis wasn't that all religious beliefs are insulated from what I'll just call ordinary or scientific standards of reasons and evidence. And what I mean by that are things like sense perception is veridical, right? It can be wrong, but it gives us evidence of what the world is like. And if we organize our sensory evidence in a systematic way, we can come up with predictive theories that explain how the world works and so on and so forth. And my only claim was that in all religions, some beliefs are held not because they're thought to answer to those evidential standards, but on the basis of other things that might be called evidence and reasons, but are different than those kinds of evidence and reasons. Now, do political ideologies have that feature? I think it depends very much on the particulars of the political ideology in question. So in the case, since I'm using the communist example, right, Karl Marx actually thought it was a scientific theory, and he tried to adduce evidence for it, right? Now, so evidence in the form of examining past episodes of historical change to show that, in fact, his theory gave the explanation for the changes. Right? Now, it turns out that Marx's theory of historical materialism can be falsified by the evidence because it doesn't explain certain kinds of historical events. So, looked at that way, yeah, it's kind of responsive to reasons and evidence. But I think it depends, and I think there will be examples, right, where sometimes, I talk in the book about, the Maoist personality cult during the Cultural Revolution in China in the 1960s, right? Sometimes people say, well, there was a kind of religious fanaticism to that, right? And I think when people say that, they're picking up on things I'm trying to emphasize in my characterization, namely that people believe certain things, right, as a matter of faith. And indeed, it was worse than that. They believed things notwithstanding all the evidence that actually counted against it, right? And I think that's why we sometimes describe certain political ideologies as having a religious dimension. I think it's partly related to this thought that it's characteristic of religion that some of the beliefs people hold are held for a different reason than a lot of the other beliefs we hold, right? I don't hold it on faith that I'm sitting up here with Jordan and David. I hold it based on kind of ordinary evidence, having met David. Right. Okay. So that's all that I think it's at stake there. But I think there are hard questions about certain political ideologies.
So, David, what would you say? So, I think a natural way to react to what Brian said is on the most charitable interpretation of, I should say, responsiveness from religious individuals to reasons and evidence. Say that you have, philosophers, scientists, whatnot, that are Christians, and they seem to be just as responsive as anyone else to reasons and evidence. How would you integrate that into an argument for allowing exemptions for special legal protection of religion. Would you have any thoughts on that?
So I guess I would go at it from a different direction. I mean, one reaction I had to this discussion about reasons and evidence, I mean, as I said, I believe that all comprehensive views are a mixture of reasons and uncertainty and decisions made under complete uncertainty. So I really don't think religion is different from other comprehensive views, although I agree that there are different forms of evidence that are admitted to some extent. But I don't really see the case for special treatment of religion as resting on that one way or another. So one of my reactions was, what work is this doing? I mean, why do we need this part of the definition to talk about whether religion warrants special treatment or not? What seems more important to me, or let me back up one step. I mean, Brian in his book is trying to argue from first principles, so in a way it kind of matters from that perspective. But I think pragmatically, it matters more from a historical perspective. Historically, religions have been singled out for oppression and have been vulnerable. I also think that the state, that the government, is not competent to make decisions about comprehensive views of the world, to decide that Christianity is less compelling than Judaism, is more compelling than Islam. And so I really think the special case for religion rests not on reasons and what kind of reasons go into a religious believer's belief, but on the status of religious individuals and groups within the society. I think that's where the special treatment is. And I'm comfortable with Brian's suggestion that other conscience claims ought to be given a similar status. And my intuition is that there wouldn't be a huge number of those conscience claims. So I don't think it would be expanding the circle a huge amount to include seriously held conscience claims against generally applicable laws. When you look at the conscience claims that have been made, they've been made in a couple of very limited areas. Serving in wars, things involving life and death is where they've been made. So I don't think it would expand the circle that much. And I really think the big issue, if you reach that conclusion as to what ought to be given special treatment, is how much of a burden does it impose on everybody else? And this is a point that Brian emphasizes in his book. If it turns out that you're going to be exempting half of the population and it's going to be a huge burden in any particular context, I think that's a reason to override the exemptions, which is what our law currently does. I mean, the nub of the discussion is whether there's a compelling governmental interest to impose the law, despite the religious or at this point religious objections, and whether what the government's doing is the least restrictive way of achieving its goal.
Real quick, before we go to questions from the audience, I'd like to hear what each of you, what your views on the Hobby Lobby decision this summer was.
This was all orchestrated so Jordan could get us to talk about Hobby Lobby.
No, that's fine. Do you want to go first, David? Or?
Sure, I mean, because mine will be simple. First of all, I think people have radically misunderstood the Hobby Lobby case. I mean, that all of the excitement that, America, corporations are taking over America and religious corporations are going to run everything else into the ground is wildly exaggerated. There are two issues in Hobby Lobby. One of the issues was, can a for-profit corporation have religious freedom rights? Can it be religiously oriented? Is there such a thing as a religiously oriented for-profit corporation? That's the issue everybody got excited about because the court said, yes, corporations can be religiously oriented. The second issue is, did the government have a compelling reason, and what the issue was, as most of you probably know, in Hobby Lobby, is these religiously oriented, very religious closely held corporations' objection to the contraception mandate in the healthcare law. And they objected in particular to 4 contraception methods that they believed were essentially abortions. And the second issue is, was the government's approach to that and its insistence that Hobby Lobby provide those services, did the government do that in the least restrictive way possible? So 2 issues. The first is, can a for-profit corporation have religious freedom rights? Second issue is this balancing test about whether there's a compelling interest and the government's used the least restrictive means. I believe on the corporate issue, Hobby Lobby is an easy case. I mean, there was an amicus brief filed by a bunch of corporate law professors. I am surprised they were willing to sign on to the brief. I mean, it's just corporate law professors saying corporations should not be able to have religious freedom rights. I think it's an easy case on the corporate law issue. The hard part of it is the second issue, is whether there's a compelling interest in least restrictive means. And the Supreme Court basically said that as long as the government negotiated a reasonable compromise so that Hobby Lobby didn't directly have to provide the contraception services, the government would be okay. So I think the reaction to the case has really been overblown.
Brian?
Well, I agree with some of that.
We're below 84% now.
Yeah. Well, I don't know. I'd have to think about how it cuts up. Taking the Religious Freedom Restoration Act as the background to this case, I think it wasn't implausible to hold. Now, you put it very broadly. What they specifically say, right, is closely held corporations can have free exercise claims. And that's plausible, right? Because the nature of the closely held corporation, right, is like the family business. That's what it was in this case. And so it was very clear that the family had a particular religious view, and their business was just a way in which the family was organizing their activities. There is, it strikes me as more dubious whether we want to say public corporations, right, have religious free exercise rights. It's not clear whether Hobby Lobby really says that, okay? And it's also very unlikely that any public corporation is going to say that for reasons that have nothing to do with constitutional law. That is, the day that General Motors says, we are Baptists. That's going to be very bad for business, right? So in that sense, I agree with David. That did get overblown. I think that's not an issue to worry about. I think it's also correct that once the court agreed that there was a burden on Hobby Lobby, right, that their free exercise right was burdened by the contraception mandate, right, the government had to lose. And the reason the government had to lose is because the government had already cut a deal with not-for-profit organizations to provide the contraception to the employees without the not-for-profit paying for it. So there was obviously a less restrictive alternative because the government had already created it and handed it out to all the not-for-profits. The part of the opinion that struck me as very dubious, however, was the way the court approached the question. So the owners of Hobby Lobby felt it burdens our free exercise of religion to have to pay for insurance coverage that will cover certain contraceptive devices that our employees, who may not share our religious beliefs, want to avail themselves of, okay? And the court said in the majority opinion by Justice Alito said, well, it's not for us to question whether that's a reasonable belief, right? And as a general matter, it's true. The court asks, is it a religious belief? Is it sincerely held? They don't ask, is it a sensible belief? But I think they can't do that in this particular instance because the belief that Hobby Lobby was putting forward was tantamount to saying, we have a sincere religious belief that our free exercise rights are being burdened. And that's a legal question for the court. And so that was the one part of the opinion that I thought was, shall we say, not well argued and could have quite reasonably gone the other way. In other words, they could have said, there isn't a burden when you're asked to pay for insurance that includes services that other people, not you, might want to utilize even though you disapprove of them. And I think it was that aspect of it that also accounted for a lot of the public reaction, right? Because we put it very simply, it looks like your boss gets to decide what medical services you can use. That doesn't seem very good, okay? Now, again, in practice, it wouldn't quite amount to that because the contraceptive services still would have been available, but paid for by the insurers. Well, it's a little complicated, but not paid for by Hobby Lobby. So that was the one part of Hobby Lobby that struck me as implausibly argued. On the other points, I'm actually inclined to agree with David.
So real quick, I just want to say before we have questions from the audience that attorneys that are here for the MCLE credit, please fill out those forms and remember to drop them off at the end near the at the MCLE table when you leave. And also, please fill out the survey cards because CLS will actually get money to hold another Veritas event if you fill those survey cards out. So please fill out your survey cards. So real quick, does anyone have a pressing question that they'd like to ask either of these fine gentlemen?
Doesn't even have to be pressing.
Yeah.
It can just be of interest.
David mentioned the University of California system, saying in effect that Christian organizations on campus getting any kind of school support cannot require practice or belief on the part of the leaders. I'd like the reaction of both participants, David and Brian, to that situation.
So, are you familiar with what's going on, Brian? Or-
I'm actually only superficially familiar, so it might help if you said a little
Just
more
very quick.
about...
So it's all coming out of the Martinez case. So what a number of universities have done is, and law schools have done this as well, is impose a requirement that for an organization to be recognized as a university organization and to have access to campus funding and things of that sort, they must adopt an all-comers policy with respect to both membership and leadership. And all-comers means that everybody has to be eligible to be considered for membership and for leaders. So your leaders, you can't say that a leader of a Christian group has to be Christian or hold to any particular set of beliefs, or a leader of a Jewish group has to be Jewish. Which is very difficult for a number of Christian organizations because they're of the view that a big objective of the organization is formation and to teach students about what it means to be a Christian in the academic setting or Jewish in the academic setting or whatever. So a couple reactions to it. So what California has said is intervarsities being kicked off of all of California's campuses. As a constitutional matter, my sense is that University of California is on very firm footing. I mean, there is a case that says, as you know, obviously, the Martinez case, which seems to me to say you can insist that that leadership be open to all people, whatever they believe. I personally think that's a bad idea for California to do that. I think it's very important to foster pluralism within the university environment as elsewhere. But I also think, and this is the part of my view that might be a little surprising to some people at least, that it's not necessarily all bad for Christian groups, because if we believe that Christianity is true, we shouldn't be afraid of people who are not Christians coming to a Christian meeting to hear about the Bible and to be involved in discussions of the Bible. So I have a kind of complicated reaction. The first is I think that California is on firm grounds. I think overall it's probably a mistake in terms of fostering pluralism, because I think a lot of groups will just go off campus, and I don't think that's a good outcome. But for the ones that do, I think there will be some surprising fringe benefits that people who would not ever otherwise hear about Christianity will hear about Christianity, and I personally think that's a good thing.
Okay, interesting. Yeah, the only thing I would add to that, I mean, it does seem to me that there's another value at play here, which is freedom of association, right? And there are contexts where freedom of association requires some freedom to say who you're going to associate with, right? And, you know, we obviously settled the legal question whether freedom of association can suffice, you know, for saying, well, I don't want to associate with African Americans, okay? But this seems to me pretty far removed from that, and especially on university campuses, and especially public universities, which tend to be very diverse in a lot of different ways. Having a safe space on campus for a certain amount of freedom of association in which there are some criteria for membership or belonging doesn't strike me as the worst thing in the world. But I think you're right, after Martinez, though I'll just say I thought Martinez was puzzling as a matter of the existing constitutional doctrine. But given the decision, you're probably right, they can do this now. So.
Well, I think that is it. It's 7:30. Brian's going to have to get out of here. However, David is going to stay around and talk with whoever wants to chat about this stuff, or really just about anything. There's going to be food, I believe, out there. Dana, I believe, just ordered that. Yep. One really quick last question.
My memory serves, the way in which the RFRA first got the Supreme Court's attention was in the area of landmarks laws, and that city of Fort, Texas, against somebody or another. And yet, my perception is that that is a way in which religion is not only tolerated, but also impinged, in the sense that churches that are made landmarks have to pay from their limited fist to keep these churches, to keep them from falling down, just as the one on South Michigan Avenue here did last week. How can your views adopt a position that would not require churches to be separately set apart and landmarked?
So what is it that you contemplate? I mean, what would be the...
I would say that churches should not be subject to landmarks laws, okay? End of story, okay? That is an unconstitutional impingement on their ability to recraft their ministry.
Brian could probably handle this better than I can, but I mean, it's not obvious to me that churches would win even under RFRA. Part of the problem with a lot of landmark laws is if they are state laws, RFRA, as you know, is invalidated with respect to state laws. It's only valid with respect to federal laws. So you'd have a RFRA challenge to a federal landmark law, but not a state one. But I don't know that they would win. I mean, even under a view that takes religious freedom very seriously, I mean, it's a neutral law, and I'm not sure what the lesser restrictive alternative would be. But Brian could probably handle this more effectively than I can.
I think that is false. I think what you said is sensible. I mean, I have to say, I don't like landmark laws either. I live in a 1907 house. If I wanted to do anything to it, I mean, I think that's partly in the background here, is I think there's a lot of reasons to be worried about landmark laws and the effects they have. I don't know that RFRA specifically helps religious institutions vis-a-vis the requirements of landmark laws.
So you just want to get rid of the landmark laws?
Well, I don't know if I want to get rid of all of them, but I think what happens is, especially in this city, where we're all ruled by our aldermen, they get carried away with these things. I'm sure everybody's got their own local story about that. That's a Chicago thing.
Well, thank you for coming down to Northwestern Law and participating in this dialogue. And thank you for everyone who came and everyone who was watching on the internet. We will have food out there. So
Thank you.
stay.
Thank you.
And thank you to the Veritas Forum.
For more information about the Veritas Forum, including additional recordings and a calendar of upcoming events, please visit our website at veritas.org.